The Subcommittee on Oversight, Management, and Accountability will come to order. The subcommittee is meeting today to receive testimony on oversight of ICE detention facilities. Is DHS doing enough? Good afternoon. We are here to discuss the oversight of immigration and customs enforcement in detention facilities and whether DHS is doing enough to ensure that ICE's own detention standards are being met. Before we start, I'd like to take a moment to acknowledge some of the challenges the subcommittee had in arranging today's hearing. We're holding two panels this afternoon because ICE declined to sit on the same panel with Nakamoto, the contractor it chose to conduct inspections on its behalf since 2011. The department's lack of cooperation makes it more challenging for Congress to do its job. As I recently stated at a meeting with DHS leaders, it's important to this subcommittee to bring everyone's voices together. That's how we can best identify challenges and find ways to solve them. This issue is particularly important to me as two of ICE's facilities, the Otero ICE Processing Center and the Cibola County Correctional Center, detain upwards of 1,300 migrants in my home district. I've visited these facilities, and I have concerns about some of the conditions of confinement, and I'm not alone in having these concerns. DHS's own Office of Inspector General last year found that these processes, that ICE's processes for oversight of confinement were insufficient to sustain compliance with ICE's own standards. It might be that inspectors are set up to fail. For example, ICE's contractor, which conducts about 100 inspections annually, is responsible for evaluating compliance with up to 42 standards composed of over 600 elements over the course of just a few days. As a result, these inspectors end up missing some clear violations of detention standards, like a phone not working properly. The OIG also observed inspectors misreporting that detainees knew how to obtain assistance from ICE officers when those detainees had indicated the exact opposite. Of additional concern is the fact that even when these deficiencies are identified, ICE's processes have not ensured that they are corrected. For example, ICE has detention service monitors on site at several detention facilities to monitor compliance with detention standards. However, these monitors told the OIG that when they identify violations, they have no means of enforcing corrective action. Instead of pressuring facilities to correct deficiencies or issuing financial penalties for noncompliance, in some cases, ICE grants waivers so that the facilities don't have to abide by these standards. For example, as the OIG reported, from October 2015 to June 2018, ICE only issued 2 financial penalties and granted 65 waivers, 63 of those waivers had no end date. One of these waivers at Otero in my district permitted low custody individuals with no criminal history to commingle with individuals with more serious criminal records. The standard that typically keeps these detainees separated is an important one that directly impacts the safety of people in detention. Finally, I have concerns that inspections by ICE's contractor announced far in advance, giving facilities ample opportunity to clean things up just in time for inspection. I understand that the OIG made several recommendations to ICE to correct these issues, and I look forward to hearing what steps ICE has taken and whether they are leading to more sustained compliance with standards. I also look forward to hearing about the oversight work that the OIG conducts at ICE facilities. The OIG's oversight work in this space has been critical in shining a light on the conditions of confinement. Recent reports have identified serious violations of ICE's standards, including food and service issues endangering the health of detainees and inappropriate segregation practices infringing on detainee safety. However, the scope of OIG's inspections is limited by its lack of subject matter experts, like medical doctors, to evaluate the quality of medical care. I'm encouraged by the fact that the OIG is developing a plan to contract with such experts who could engage in this oversight work, and I hope to hear that this plan is being put into action. I want to thank the witnesses who are here today, and I look forward to your testimony. The chair now recognizes Ranking Member of the Subcommittee, the gentleman from Texas, Mr. Crenshaw, for an opening statement.
Thank you, Chairwoman Torres-Small, and thank you to all of our witnesses on both panels for being here today. I'm pleased we are holding this hearing regarding the oversight of ICE detention facilities. It's extremely important. I'm also pleased we were able to work together and resolve some of the problems coordinating witnesses and panels to have the key stakeholders necessary for the productive hearing this issue deserves. It should be noted that it is long-standing practice not to have the agency and the contractors for that agency on the same panel, which is why we ended up having two different panels. I'm also hopeful that the Office of Civil Rights and Civil Liberties will still provide their testimony prepared for this hearing, even though they were disinvited earlier this week. And I hope that in the future that the agency over which we are conducting oversight, in this case ICE, would be the first to be invited to testify. This is an important issue to examine. I share the majority's concern regarding the necessity of enforcing the standards for safety and security of ICE detainees. The health and well-being of those detained in the United States is not a partisan issue. I've been very public in my praise for the Department of Homeland Security and the individuals who work each day to keep our country safe. The men and women of U.S. Immigration and Customs Enforcement have some of the toughest jobs in the department. ICE is tasked with enforcing U.S. immigration law and removing individuals who pose a threat to the national security, public safety, or seek to exploit our immigration system. Their job is made even more difficult when they are publicly and unfairly vilified by public figures. The false narratives spread about ICE are utterly reprehensible. Individuals primarily targeted for removal by ICE include convicted criminals, gang members, repeat immigration violators, and those ordered to be removed by an immigration judge. As the flow of immigrants increases, the job of ICE becomes even more difficult. They must devote their resources to rooting out those that pose the biggest threat. However, those resources are stretched thin. The safe and secure detention of individuals prior to removal from the country is one of the most important duties that ICE devotes resources to. Although detention is primarily done through contractors, as the agency responsible for these individuals, ICE must ensure that proper care is provided. ICE must use its oversight authorities as well as its contracting authorities to ensure its detention standards are met. ICE does its own inspections every 3 years and hires private contractors to do inspections annually. Additionally, ICE has individuals in a number of facilities who are tasked with on-site review of the daily operations. All this seems like the recipe for conducting vigorous oversight. Unfortunately, however, it seems, as is frequently the case with government agencies, there was a lack of communication and coordination among the divisions within ICE. It is my understanding that ICE has agreed with the recommendations of the Inspector General's office and is working to address these issues. I look forward to hearing from our witnesses today on how we can ensure ICE detention standards are met in the future. I'll yield back the balance of my time.
Other members of the committee are reminded that under the committee rules, opening statements may be submitted for the record. I welcome our first panel of witnesses and thank them for joining today. Our first witness is Ms. Jenny Nakamoto, president and sole owner of the Nakamoto Group, Incorporated. Ms. Nakamoto has provided professional and administrative support to the federal government and private industry since 1990. Her company contracts with ICE to conduct inspections of ICE's detention facilities. Our second witness, Ms. Catherine Hawkins, is the senior legal advisor for the Constitution Project at the Project for Government Oversight. Her work focuses on national security, immigration, and human rights. Prior to her work at POGO, she served as a National Security Fellow for Open the Government. Without objection, the witness's full statements will be inserted in the record. I now ask each witness to summarize her statements for 5 minutes, beginning with Ms. Nakamoto.
Thank you for the invitation to appear before this committee. I want to first apologize for what appeared to be our resistance to come to this hearing to discuss the details of our work with ICE. Our contract has a clause within the contract, federal regulations, that forbids disclosure of these details, and we were hesitant to get involved at the risk of our contract. The Nakamoto Group is a woman-owned, minority-owned, small disadvantaged business headquartered in Frederick County, Maryland. My great-grandparents immigrated to the United States from Japan. My maternal grandparents were both born in California, making them United States citizens. After Pearl Harbor, the presidential order was issued to incarcerate all Japanese, regardless of their citizenship status. My maternal family were living in California and had to relinquish all of their property, including any businesses that they had. They were given one trash bag to fill of personal items to take with them and had to leave everything else behind. Our family was spread out to various internment camps across the country. My maternal grandparents were incarcerated in a Japanese internment camp in Arizona. They were there long enough to meet, fall in love, get married, have a baby, my mother, and become pregnant again with my aunt. Since they had to start over, they were offered employment at a food processing factory before they were released, and they chose to move to a small town called Seabrook in southern New Jersey, where ultimately I was born. My father was born and raised in Hilo, Hawaii. My grandfather returned to Japan soon after he was born. My father was the youngest in a large broken home, and he was raised by several of his older brothers. My father served for more than 20 years in the United States Army. He served 2 tours during Vietnam and served on what was one of the first all-Japanese American Green Beret units. Upon his retirement from Fort Ritchie, Maryland, we relocated to Frederick, where I grew up. Because my parents did not have a lot of money, I worked during high school and have been working since I was 15 years old. Shortly after high school, I was able to obtain a secretarial job with the government at the Department of Health and Human Services. I worked there for over 6 years before leaving to work for 3 other successful minority-owned government contracting firms. I learned about government contracting during those 7 years, and I decided to take a chance and start my own company. I started this company in 2003. It was the same year that I lost my late husband to police suicide. I still volunteer for his Fraternal Order of Police and have volunteered for them for over 20 years, serving as their executive assistant to the executive board. The Nakamoto Group was certified in the Small Business Administration's 8A program in 2004. We successfully graduated the certification in 2013. The first contract awarded to my company was in 2004 to maintain a hotline entitled Insure Kids Now, which is a hotline that provides either free or low-cost health care to kids through the state's Children's Health Insurance Program within the United States and its territories. We still maintain that contract after 15 years, and it now includes another hotline entitled 311 Baby, which helps expectant and new mothers providing information via phone and text. For the last 15 years, we have obtained logistics contracts with the Food and Drug Administration and the Department of Health and Human Services. From 2006 to 2007, we had a contract with the Food and Drug Administration to help them hire Hispanics to increase diversity within their workforce. We continue to provide logistics support for FDA's CEDAR advisory committees. Our most current and longstanding logistics contracts has been with the Office of Rural Health Policy to run logistics for the National Advisory Committee on Rural Health and Human Services. We also provide logistics for several other policy meetings regarding telehealth in rural America from 2010 to 2013. In 2005, we obtained a contract with the now-dissolved Office of the Federal Detention Trustee, which was a department under the Department of Justice. We won a place within a blanketed purchase agreement to provide detention expert support services to the Office of the Federal Detention Trustee. Using performance-based detention standards, we sent teams to provide expert specialized service consultation by conducting facility reviews of non-federal contract jails and detention facilities which house U.S. Marshal Service and Immigration Customs Enforcement detainees. In 2007, we were asked to attend a meeting at ICE headquarters where we were asked to perform on-site monitoring services and provide monthly technical assistance and included full-time monitors for 40 of the largest ICE detention facilities and monthly, quarterly, biannual reviews of other small ICE detention facilities. The goal was to ensure that the facilities were in compliance with the standards. ICE piggybacked on that existing contract that we had at the time with the Department of Justice, and we did this type of work for them from 2007 to 2010.
Ms. Nakamoto, your time is up if you want to include a few seconds of concluding remarks. Or we can just, the rest can be entered into the record.
Okay.
Ms. Hawkins.
Chairwoman Torres Small, Ranking Member Crenshaw, and members of the subcommittee, thank you for the opportunity to testify today. I'm a senior legal analyst for the Constitution Project at the Project on Government Oversight. POGO is a nonpartisan watchdog that investigates government abuses of power. As part of that work, my colleagues and I have done a series of investigations into conditions in ICE detention. We found evidence of inadequate medical care, inadequate mental health care, and overuse of solitary confinement. These are chronic problems, but they've grown worse and worse as ICE has detained more and more people. ICE detention centers are subject to various forms of oversight by DHS. There are annual inspections by the Nakamoto Group, on-site monitors, inspections by different offices within ICE, and inspections by the DH Inspector General and the Office of Civil Rights and Civil Liberties. This sounds like a lot of inspections, but the system is failing to ensure compliance with ICE's own detention standards. The Nakamoto Group's inspections occur most often and are the only ones that can trigger loss of a detention facility's contract, but they often fail to uncover serious violations. Other inspections are more thorough, but they often remain hidden from Congress and the public, and ICE fails to make changes they recommend. As a result, inhumane and unsafe conditions can persist for years. In some cases, the violations rise to the level of deliberate indifference to detainees' medical needs, which is unconstitutional. To illustrate the problems, I'll describe our findings on 3 of ICE's largest detention facilities. In September 2018, the DHS Inspector General reported on an unannounced inspection of the Adelanto Detention Center in California. They found sheets braided into nooses in 15 detainee cells, inadequate medical care, and overuse of solitary confinement. The next month, the Nakamoto Group conducted its own previously announced inspection of Adelanto. Nakamoto not only found that Adelanto was in compliance with 40 of 40 ICE detention standards, but accused the Inspector General of writing an erroneous and inflammatory report. They dismissed the nooses as a housekeeping violation, not a suicide risk, disregarding the fact that an Adelanto detainee used a bedsheet to hang himself in March 2017. We recently uncovered a 3rd investigation of Adelanto by the Office of Civil Rights and Civil Liberties, or CRCL. CRCL visited Adelanto in December 2015 and November 2017. In 2015, CRCL had warned ICE that Adelanto's medical leadership was not competent. In 2017, they found no evidence that corrections were made to address this issue. This led to, in their words, inadequate detainee medical care that resulted in medical injuries, including bone deformities and detainee deaths. CRCL also found that mentally ill detainees were being placed in solitary confinement instead of being treated, sometimes for shocking lengths of time. Overuse of solitary is a problem throughout the ICE system. Sometimes it has fatal consequences, as it did for 2 men who committed suicide at the Stewart Detention Center in Georgia in May 2017 and July 2018. Both Giancarlo Jimenez-Joseph and Efrain de la Rosa suffered from schizophrenia. Instead of receiving psychiatric treatment, both were placed in solitary confinement for weeks as their symptoms grew more and more alarming. Both hanged themselves in their isolation cells. Despite the 2 deaths, Nakamoto Group inspectors found that Stewart was in compliance with all 39 applicable ICE detention standards in both 2017 and 2018. Inadequate medical care led to another death at the ICE detention center in Aurora, Colorado. Kamyar Samimi went into methadone withdrawal when he arrived there. For 2 weeks, his symptoms grew worse and worse, but medical staff believed he was faking or exaggerating them, even when he became too weak to sit up. There were many other credible reports of medical neglect at Aurora, including one case where a detainee's untreated bed sores became so severely infected that his leg had to be amputated. Despite all this evidence, Nakamoto Group inspectors found that Aurora was in compliance with 41 of 41 applicable detention standards in both 2017 and 2018. Let me close with some steps Congress can take to improve oversight of ICE detention. Number 1, Congress should require DHS to impose financial consequences for documented violations of detention standards, no matter which type of inspection uncovers them. Number 2, in 2017, DHS suspended a policy that limited detention of individuals known to be suffering from serious physical or mental illness, who are disabled, elderly, pregnant, or nursing, or whose detention is otherwise not in the public interest. Congress should require DHS to reinstate it. Number 3, Congress should place binding restrictions on DHS's ability to transfer funds in order to expand detention. Number 4, Congress should strengthen the authority and transparency of the Office of Civil Rights and Civil Liberties. Thank you very much. Happy to take any questions.
I thank all the witnesses for their testimony. I will remind each member that he or she will have 5 minutes to question the panel, and I now recognize myself for questions. Ms. Nakamoto, thank you for being here today, and I recognize your concern about the contract, but your ICE contract does not prohibit you from testifying at this congressional hearing, correct?
Correct. It's just,
Great.
but this is public.
Thank you. And so, as I've noted in my opening statement, you're responsible for, or Nakamoto inspectors are responsible for reviewing 42 standards that include over 600 elements in just a few days. The OIG is not the only or even the first entity to raise concerns about that process. In fact, more than 3 years ago, the Homeland Security Advisory Council recommended that ICE move away from a broad checklist for inspections. Ms. Nakamoto, does ICE's current statement of work allow your company to conduct thorough inspections?
They do. All of my staff have to not only go through the checklist, but they have to know the standards. They have to know the actual information within the standards and the components within those standards.
So 600 elements in 3 days, you have enough time to get that done?
Yes.
You have enough inspectors?
Yes.
Okay, and you don't need a narrower scope to make sure you are verifying all of those items?
No. The 3 days on site are to perform interviews with detainees, staff, and to see the facility itself. The rest of our report writing or putting all of it together happens after we leave.
So how then do you explain the reports in the OIG report that, for example, a phone wasn't working and they just neglected to check and see if there was a phone, if the phone directed them to, or gave them the ability to make a complaint?
I don't know all of, I don't have the OIG report memorized, but I know that my staff checked into it.
What about A file documentation being reported as complete without actually checking the A file?
My staff check the files according to the standards.
So you're disputing the OIG report on that?
I'm not disputing it. I'm telling you that my staff know what they have to look at within the standards.
What about CDL licenses being reported as existing without confirming the documentation?
I don't agree with that. My staff always check for the credentials that are required within the standards are always checked by the staff.
The OIG was incorrect in making that observation.
I believe, I guess if they said that we didn't, then
What about only in interviewing detainees who speak English or using a guard to interpret in Spanish, someone who is in charge of guarding the facility?
I think there's different ways to find out information of what is going on at the facility. And some of the interview process is informal, some of it is formalized. We've, in fact, since the OIG report came out, we have since formalized the interview process as they suggested.
Have you formalized the process for making sure that you have enough Spanish-speaking inspectors?
Yes, we have a language line that we are also able to use at any facility.
In terms of Spanish-speaking inspectors and certifying that they do actually speak Spanish, do you have a system for that?
I don't understand what you're asking me.
Okay, so you don't have a system for establishing if an inspector actually does speak Spanish, if they are claiming to?
We have about a quarter of our staff that speak Spanish.
It says they speak Spanish. How do you confirm it?
They ask the detainees questions in Spanish.
But you don't. Do you speak Spanish?
I do not.
Can you then determine that they are using correct language? Okay. Just quickly to move on, ICE has concurred with OIG's recommendations for redefining the scope of work. Why hasn't Nakamoto?
Why hasn't Nakamoto?
Concurred with the recommendation to revise the statement of work?
To revise the statement of work.
so that you have more time or are more targeted in your, in evaluating those elements?
I mean, we've been doing this for a long time. We do this for other agencies. The same amount of time is on site. We've never said that we needed more time.
Thank you. I'll recognize my colleague, Mr. Crenshaw from Texas.
Thank you,
5 minutes.
Chairwoman. I'm going to follow up with that exact line of questioning about the more time issue, because it seems from our perspective that Nakamoto inspectors said to, I believe, the Inspector General that there is more time required. Is that not what you've heard?
That there is more time?
More time per inspection. More time per inspection in order to meet the criteria for all of those bullet points that you have to hit.
I mean, my staff have not complained about the amount of time that they have. They have the 3 days on site, and that's how long it's.
They haven't complained to you specifically about it, because it's from other reports they have said that. So it's at least something to think about, or at least get feedback from your own staff on, I believe, because there does seem to be quite a few requirements that perhaps that there's not enough time to look into. And if that is the case, then restructuring the requirements is certainly in line. 4 days instead of 3 days is not exactly a huge stretch of the imagination. It's something we could easily do. But aside from the time difference, do your inspectors come to you with any other issues regarding the inspection process? Is it not clear enough? Okay, we've already established you think they have enough time, but what else?
We work very closely with ICE. My team works very closely with ICE. If there's any issues that come up, then we have a good relationship with letting ICE know what the issues are.
Mm-hmm. What about the OIG report? Just generally speaking, do you think that report is valid? You don't have to go into specifics because, like you said, you don't have it in front of you. But generally speaking, I mean, what issues do you agree with or disagree with in that report?
I think that what they see at the time that they're there, or what they looked at, could be different from what we're looking at. We're looking at things from a different perspective because our team kind of knows what to look for when they go on site, so they, based off of whatever they're seeing, based off of their past experience, our team has, over 35 years experience in detention management, so they know kind of what they're looking at when they walk into a room.
Ms. Hawkins, I'll go to you because you said some things that were very shocking. For instance, the nooses. You said that you all found nooses which the Nakamoto group did not find. You want to expand on that? Are you implying that, how many nooses are we talking about? And what's the implication there?
Sure. So just as a point of clarification, I was conveying the OIG report's findings.
Okay. Okay. Do you know how many nooses we're talking about and what the implication of that is?
15 of 20, and I do think that.
Okay. Well, then, and you proceeded to connect that to suicide. So the implication is that there's almost a factory line of nooses being created for suicides, which probably not the case.
Yeah.
Right. But that was the implication in your statement.
So my statement was brief, but if you look at the report my organization did on this dispute.
Would it be maybe logical to think that the sheets were being braided for the reasons that Nakamoto Group claimed they were, which was privacy within the cells? Is that possible?
Yeah, I think.
Would it be important to maybe clarify that when we say something like there's a bunch of nooses found in a facility? I mean, it's a pretty important clarification, right?
Yes, if I could respond, please. My organization said that, and the Inspector General said that they were primarily used for privacy. But
just an important clarification because this stuff gets really out of hand. You also mentioned some suicides, which in other facilities, which are absolutely terrible. Were you connecting were there deficiencies that were noted later, which were not caught by the inspectors, that were directly connected to those incidents?
Yeah, I think chronic
what?
understaffing in medical care and mental health care.
According to ICE standards or according to your standards?
According to ICE standards.
Okay, so do you have any more detail on exactly what we're talking about here?
I'd refer you to the detainee death review for the Jimenez-Joseph case, which became public recently. I don't know if the detainee death review for the other detainee who committed suicide at Stewart is publicly available. I'd definitely encourage the committee to request a copy of that to get details on that.
Okay, thank you.
Thank you. The chair recognizes for 5 minutes the gentlewoman from New Jersey, Ms. Watson-Coleman.
Thank you, Chair. Thank you very much for being here. Thank you for your testimony. Ms. Nakamoto, how many employees do you have that are inspectors? Could you put your microphone on, please?
Sorry. We have 45 part-time employees and 12 full-time employees.
And how many facilities do you have a contractual relationship with ICE to do whatever it is I'm going to ask you that you do? How many facilities?
So our contract is with ICE,
For how many facilities?
as many as they ask us to inspect.
Do you have any limit in your contract that says you are being contracted to do 50 of the 200 facilities or whatever?
The way they do it is in intervals, and we inspect at least about 120 a year
Of facilities?
facilities.
With 45 part-time inspectors and 12 full-time? Mm-hmm. Okay, and what are the credentials that these inspectors and the experience that they're supposed to have?
They have to have, within our statement of work, it declares what the credentials have to be.
What I'm asking you, what do they have to be?
They have to have 10 years' experience in a correctional setting. They have to be warden. We have wardens. We have superintendents of corrections. We have
And did they actually do the inspections, or do they oversee other inspections that are done?
no, they actually do the inspections.
And so what is this 3-day limitation? Is this something that the contract calls for? Is this something that you all decided was a best practice? Is this,
It's within the contract. We have a similar contract with the Department of Justice, and it's the same thing.
when does your contract run out with ISIS?
It just,
With ICE, I'm sorry,
I believe,
March.
of 2020.
What is the value of your contract?
I don't have that in front of me.
What do you estimate it to be about? Who do you have with you on staff?
I'm sorry?
Who's with you from your staff?
My vice president and my chief financial officer.
Then your chief financial officer, I'd be able to whisper in your ear what the value of your contract is.
$3 million.
It's a lot of money. Okay. Ms. Hawkins, first of all, you are only testifying about the OIG report. Nothing that you or your organization have seen for yourself, right?
One of my colleagues has gone to Adelanto, but my reporting relies mainly on government documents and a whole lot of phone interviews.
Okay. So in the facilities that you mentioned, there was inadequate mental health services, inadequate other health care services, inadequate food, and another inadequate something else. I don't remember what something else was. Are any of those the facilities that the Nakamoto Group has a contract to inspect?
Yes, they're some of ICE's largest facilities, so I think they're inspected on an annual basis. And
Okay. Ms. Nakamoto, in 2009, ICE detention facilities, they frequently failed inspections, and beginning in 2009, appropriations law precluded DHS from continuing contracts for facilities if the two most recent overall performance ratings evaluations received are less than adequate. In the last 5 years, are you aware of any of the over 72-hour facilities that has received an overall final rating of less than 2, adequate? Less than adequate? Did your inspections?
Are you asking me if we have any,
I'm asking you if you have knowledge of any of these facilities, of any facilities that you all are responsible for inspecting that has received an overall final rating of less than adequate?
yes,
How many?
6 this year alone.
And what did you do with those findings?
We put them in the report and submit it to ICE.
And what has happened in those facilities?
Well, one that I know off of the top of my head had a follow-on that we went back after they established a corrective action plan, and our team goes back in after so many days, and we have to go in and inspect it again.
Let me ask you a question real quick.
I
Do you know,
apologize.
I have 16 seconds, 19 seconds.
Actually 20 over.
Oh.
I'm sorry. Thank you so much, Ms. Watson-Coleman.
Thank you, I yield back.
The chair recognizes, sorry. The chair recognizes for 5 minutes the gentlewoman from Nevada, Ms. Titus.
Thank you. I'll yield some time to Ms. Watson-Coleman so she can finish her question.
Thank you to my colleague. I just wanted to know, any of these facilities were facilities that had two ratings, two sequential ratings of less than adequate? And if so, are they not supposed to lose their ability to serve in this capacity? And to your knowledge, have any of them? That's my question. Thank you.
I don't know. I could get that information and submit it for the record.
Thank you.
I don't have that information in front of me.
Thank you. Thank you.
Reclaiming my time. Thank you. Ms. Hawkins, last month your organization, POGO, released a report on the increased use of solitary confinement, or segregation it's called by ICE. And according to the report, the Henderson Detention Center, which is in southern Nevada, was among the top 15. They used segregation 121 unique times, 121 unique placements, and 16 of those placements lasted more than 75 days. I wonder if you could explain what ICE detention standards dictate regarding the use of segregation, and if you're aware of any waivers that were granted by ICE for compliance with the standards.
Thank you for your question. I can probably speak more generally to ICE's waiver process and segregation standards than specifically regard to the Hendersonville facility.
Okay.
In general, in 2013, ICE directed that facilities reform their practice on segregation, improve reporting on when vulnerable detainees are placed in segregation or anyone is placed for a long period, and try to use it only as a last resort. They also recommended that facilities try to, when a detainee is held in administrative segregation, protective custody, or for health reasons or other reasons that are not punishment for a disciplinary infraction, that they should receive the same privileges that detainees in the general population receive, which would mean they don't spend 23 hours locked in their cell. We've found, speaking to former ICE officials and inspectors and others, that exception has not been implemented. Most facilities say that it's just not practical for them to give people privileges in administrative segregation. And most ICE facilities are jails, and county jails, they just continue to have segregation mean solitary. And so that provision isn't being adequately implemented.
So is that when they grant a waiver? Are there any standards for granting waivers?
I don't know if, I think I would need to examine the more detailed inspections on the use of solitary. I don't know if they're in, I know that on DHS website, there's now a list of waivers, and I don't know if it's one of those or if it's just a general practice where it's found to be technically compliant with the standard, because the detention standards do tend to have some flexibility in their language.
Is this something, Ms. Nakamoto, that you check when your inspectors go out to look into the use of solitary confinement?
We do. There are standards, within ICE standards, there are standards that are for segregation. And our staff go through and ensure that the standards are within compliance at the facilities.
Do you find those numbers kind of high, 121 placements and 16 of them lasting more than 75 days? Over just a year and a half?
Well, segregation and solitary confinement are not the same. And mental
Okay, well,
health-
how about explaining to me what the difference is?
Well, segregation is, there's different variants of this, of segregation. It could be for disciplinary, it could be for administrative. There's different types, and then within those types, there's different components within the standards.
It doesn't seem to me you know very much about this business.
Well, I have.
My time's up.
And we'll do another round. I'd appreciate it if folks would stay if they have other questions. I want to follow up on announced versus unannounced visits. Mrs. Nakamoto, when you conduct an inspection for ICE, how much notice does a facility get?
I believe 60 days, 30 days.
Okay. Ms. Hawkins, when conducting an inspection of a detention facility, is it better to announce the visit ahead of time or to conduct the inspection unannounced?
Other things being equal, it's better to conduct an unannounced inspection. There's, as you mentioned in your opening statement, there's a tendency to clean things up before the inspectors arrive. One caveat to that, I know that the Office of the Inspector General conducts unannounced inspections that have been very valuable in bringing poor conditions to light. The Office of Civil Rights and Civil Liberties does tend to announce their inspections further in advance, but they do so in part because they bring independent experts along, and so part of why they announce the inspection is to request that medical files be pulled for the medical inspector to interview, to make sure that they're able to speak with the clinical staff. And they are doing a really in-depth look. They do many fewer inspections than the Nakamoto Group does. And so there can be a place for inspections announced in advance, but if it's going to be a quick check to, check the food, check the cleanliness of the cells, things of that nature, it's much better to be unannounced.
Thank you, Ms. Hawkins. Committee staff recently visited a few ICE detention facilities in Mississippi and Louisiana. Staff heard from detainees that prior to their arrival, walls were painted, new curtains were put up, and even flower beds were placed outside. Do you think it's wise to give facilities advance notice when conducting these inspections, Ms. Nakamoto?
Well, currently, we have another contract with the U.S. Marshal Service where we don't announce.
And do you think that's better?
We just do what that contract does, unannounced visits, and or unannounced inspections, and this contract does announced inspections. It's ICE's, we kind of do what it says in our contract. So they announce that it's their,
So, given your experience inspecting facilities, do you find that you more regularly determine the true conditions of a facility if you are unannounced?
I think so.
Thank you. Thank you. I'll yield the rest of my time and recognize the gentleman from Texas for 5 minutes, Mr. Crenshaw.
Thank you, Madam Chairwoman. Ms. Nakamoto, have you ever recommended that a facility no longer be utilized by ICE or made specific recommendations about what must be improved at a facility? Just trying to get a sense of the process there.
Okay, so what we do is we provide a recommendation based on whether or not the facility met the standards, the components within the standards met the standards. To answer Ms. Titus's question, I believe, none of the failed 2 consecutive inspections, we've never had that. But we have had where all of the detainees were removed after a failed inspection. So we recommend on all of our reports what the final recommendation is based on however many components they met or did not meet.
Okay. What were some of the more serious examples that you would cite? I mean, it's good for everybody to understand.
Like life safety issues, medical issues, their food. Those are the major things. If there's a life safety issue, then it would.
What would be an example of a life safety issue?
Well, I don't know the standards by heart,
Okay.
but if there's certain rules within the life safety issue that, or the life safety standards that, like for example, fire drills. They're supposed to do fire drills a certain way, a certain time, a certain amount of times throughout the year. So, I mean, that's just like an example of one of the
Okay.
things that they have, their safety inspector has to go through.
The reason I ask for examples is because it's important to realize if we're saying, when you say the words life safety, that could mean something very extreme. When you say fire drills, it's a little less extreme. So I just really that's why I'm trying to get at some
Okay,
examples here. And if you don't have any, we don't have any. Going back to the scope, I mean, one of the main problems it seems, and one of the reasons there was a report in the first place is because the Office of Detention and Oversight finds additional deficiencies in the same facilities that Nakamoto Group did not. You have a much broader scope than they do. I mean, can you speak to that? Is that the right way to do things? Should the scopes be similar? Is it better that they're different because there's overlap? And what's your general take on the scope of inspection for Nakamoto Group as per the contract?
Well, comparing our inspection compared to their inspection, it's my understanding that their inspection is more targeted based off of something that if our report says that they don't meet the standards within this many standards or whatever, then they send their team in. But the difference is that they're sending in more people to inspect for less standards and less components because it's a more targeted inspection of.
I see. Does that make your job more difficult when you have a much broader scope?
I don't think it makes our job difficult. We have access to those reports. If there has been an ODO inspection at the facility we're going to, we get their report so we can see whatever findings they found to make sure that they've.
Yeah, I guess the question is about thoroughness. You know, if your scope is so much more broad than ODO's, is there a lack of depth within the inspection that is subsequent to that scope?
I think the scope, for our scope of work, it talks to the whole amount of standards, all of the ICE detention standards. They created all of these standards, and they all must be reviewed annually. The targeted inspections are just that, targeted, so they're only looking at a certain.
I see. You're saying that you're comparing apples and oranges
Yes.
to an extent. Okay. Thank you. Thank you, Madam Chair. I yield the rest of my time.
Thank you. The chair now recognizes for 5 minutes the gentlewoman from New Jersey, Ms. Watson-Coleman.
Thank you. Ms. Nakamoto, your inspections are annual, which means that these facilities know that you're coming just once a year, right? And you're there for 3 days.
Yes.
And do you go like a clockwork? Is it a year from the time you went before? It can sort of anticipate when you're coming, even if you don't call them and tell them.
Well, we receive our schedule from ICE.
Oh, okay. Can you tell me really quickly, can you list the other federal agencies you have a similar contract with, some of which you do inspections without notifying people in advance? What other agencies do you have a contract with?
U.S. Marshal Service?
And that's it?
Yes?
That's the only other one?
Yes.
Okay. In December 2018, letter to members of the Senate, you quite aggressively disputed some of OIG's reporting. In fact, the letter pulls quotes from your inspection of the Adelanto facility, directly responds to some of the OIG findings. For example, you allege that the OIG's findings in the Adelanto facility regarding hanging nooses, or whatever you want to call them, and inadequate dental care was inaccurate and an embarrassment to their office and ICE. Is it part of your contract with ICE to refute findings that the OIG or other groups find in their inspections of facilities? That's a yes or a no.
No.
You also said in your letter that our reports can include only that which was verified while we were on site, notwithstanding any changes that may have occurred before or after the inspections. If your inspectors were at Adelanto in October 2018, how could you then dispute that which was observed by the OIG 5 months earlier? For example, you claim the OIG was wrong in noting that a detainee in a wheelchair had not left his wheelchair since his recent arrival and had not accessed any of the hygiene products in the bag given to him, but your inspectors were not present for that inspection, so how could you possibly claim that the OIG's findings were not true?
Because my staff went back and looked at the actual records.
Did you see the man sitting in the wheelchair, or had he been moved?
They
5
asked,
months later, ma'am. 5 months later. Finally, your letter says that DHS ICE detention program has dedicated significant resources, and they certainly have, to ensure the proper care of ICE detainees in compliance with the standards. Do you think that it is appropriate for your company to make that kind of statement that suggests ICE is doing everything properly, even though I know that you're particularly a beneficiary of their resources? Do you believe that that's a reasonable position for you to take? Can I have a yes or a no? Can I take your silence as a yes or a no? Ms. Hawkins, are you familiar with the Nakamoto's letter?
Yes,
Did you all have a position on it, whether or not it raised concerns about their objectivity?
It did strike me as strange to see a criticism of a previous inspection in the Nakamoto inspection. I looked into this a bit when I wrote an article on ICE inspections, which was published earlier this year. And one of the criticisms that Nakamoto made of the OIG inspections were that OIG didn't have people with experience in detention or corrections. And when I asked around, people said, well, that's true. It is possible that OIG got certain details wrong or misunderstood things. But then, so that's why it was so striking to see the reports from the Office of Civil Rights and Civil Liberties, which were from before both the OIG report and the subsequent Nakamoto report. And if anything, they were more critical than the OIG was.
Thank you both for your testimony. I'm now going to welcome our second panel of witnesses and thank you for joining us today. Our first witness is Ms. Diana Shaw, Assistant Inspector General for Special Reviews and Evaluations at the DHS Office of the Inspector General. Prior to serving in this role, Ms. Shaw served... Oh, okay. I'm sorry, I apologize. We'll wait till you're seated. All right, thank you so much. I apologize for the early jump start here. I now welcome our second panel of witnesses, and I thank you for joining today. Our first witness is Ms. Diana Shaw, Assistant Inspector General for Special Reviews and Evaluations at the DHS Office of Inspector General. Prior to serving in this role, Ms. Shaw served in several leadership positions within the OIG, including AIG for Legal Affairs, Acting Counsel to the IG, Director of the Special Reviews Group, and Acting AIG for External Affairs. Our second witness, Mr. Ty Johnson, is the Assistant Director for Custody and Management, Enforcement and Removal Operations at ICE. Mr. Johnson began his career with former Immigration and Naturalization Service in 1992. Since transferring to ICE headquarters in 2007, he has served in a number of leadership roles, including as Chief of Staff for the Office of Detention Policy. Without objection, the witness's full statements will be inserted into the record. I now ask each witness to summarize his or her statements for 5 minutes, beginning with Mrs. Shaw. Ms. Shaw.
Chairwoman Torres-Small, Ranking Member Crenshaw, and members of the subcommittee, thank you for inviting me to discuss OIG's recent work regarding oversight of ICE detention facilities. ICE is responsible for overseeing the administrative detention of tens of thousands of removable aliens. As of this summer, ICE had approximately 54,000 beds occupied across approximately 200 detention facilities nationwide. These facilities are governed by standards that aim to establish consistent conditions of confinement in the ICE detention system. In an effort to ensure compliance with these standards, ICE has developed a multi-layered approach to detention oversight, which includes a combination of on-site monitoring and inspections performed by ICE personnel and contracted service providers. These oversight activities have resulted in the identification and correction of numerous instances of noncompliance with detention standards. However, the volume of new and repeat deficiencies identified through the OIG's independent inspections raises questions about the overall effectiveness of ICE's multi-layered oversight approach. Since fiscal year 2016, the OIG has been conducting unannounced inspections of ICE detention facilities. These unannounced inspections have identified a range of deficiencies, including unreported security incidents, dangerous mishandling of food, dilapidated physical conditions, and unaddressed security risks. For instance, the OIG staff found that staff at the Essex County Correctional Facility in New Jersey had failed to report to ICE a loaded handgun discovered by a detainee in a facility bathroom. At the Adelanto Processing Center in California, a facility at which at least 7 suicide attempts by hanging were made in less than a year, OIG inspectors observed braided bed sheets, referred to as nooses by center staff and detainees, in 15 of the 20 cells we visited. Serious issues like these raise questions about the effectiveness of ICE's multi-layered approach and prompted the OIG to review the entities involved in providing oversight at each layer. At one layer is the Nakamoto Group, a private company with which ICE contracts to annually inspect facilities holding ICE detainees. At the time of our review, Nakamoto was inspecting about 100 facilities per year to evaluate compliance with 39 to 42 detention standards. ICE's Office of Detention Oversight, or ODO, provides another layer of oversight. At the time of our review, ODO was inspecting approximately 30 facilities per year to determine compliance with 15 to 16 core standards. Finally, ICE stations detention service managers, or DSMs, on site at select facilities to continuously monitor compliance with standards. The OIG's work has revealed shortcomings within each layer of this system. For instance, the inspection scope outlined in ICE's contract with Nakamoto is much too broad to ensure thorough inspections. As a result, Nakamoto's inspections do not always fully examine actual conditions at the facilities or identify all compliance deficiencies. In contrast, ODO inspections are narrower in scope and use effective methods to thoroughly inspect facilities. However, ODO's inspections are relatively infrequent, making it difficult for ODO to ensure that facilities are addressing all deficiencies. Finally, while the DSMs providing on-site monitoring at facilities frequently identify deficiencies and propose corrective actions, they have no authority to compel implementation of those actions. As a result, it falls to ICE field offices, some of which may be resistant to working with the DSMs, to implement necessary changes. The challenges the OIG has identified at each layer of ICE's oversight system render the overall approach less effective than it otherwise could be. Meanwhile, ICE continues to spend millions of dollars on detention oversight without achieving comprehensive, consistent compliance. ICE can and should be doing more. For instance, ICE does not fully utilize tools available to it to drive compliance among its contractors. Our recent review of ICE's management of detention contracts found that ICE is failing to use quality assurance tools and impose consequences for contract noncompliance. Moreover, we found that instead of holding facilities accountable through available financial penalties, ICE frequently issued waivers to deficient facilities, exempting them from having to comply with detention standards. Until ICE fully implements appropriate corrective action, ICE's multi-layered approach to oversight will not be as effective as it needs to be. Ms. Chairwoman, this concludes my testimony, and I'm happy to answer any questions you or the subcommittee may have.
Thank you. I now recognize Mr. Johnson to summarize his statement for 5 minutes.
Chairwoman Torres-Small, Ranking Member Crenshaw, and distinguished members of the subcommittee. Thank you for the opportunity to testify today regarding ICE's oversight of its detention facilities. ICE's enforcement and removal operations manages and oversees the nation's immigration detention system, excuse me, one of the most highly transient and diverse populations of any detention or correctional system in the world. Detainees placed in ICE custody represent virtually every nation on earth, have various security, classification, and threat levels, and often arrive in ERO custody with complex medical and complex detention and medical needs. ERO takes the health, safety, and general welfare of its detained population extremely seriously and is committed to continually evaluating and improving the care detainees receive. Through a robust inspections program, the agency ensures detention facilities used to house ICE detainees do so in accordance with ICE national detention standards, which are often much more rigorous than those that apply to other detained populations. These standards were promulgated in cooperation with ICE stakeholders, the American Correctional Association, and representatives of non-governmental organizations to ensure that all individuals in ICE custody are treated with dignity and respect and provided the best possible care. ICE uses 3 sets of detention standards for its adult detained population: the National Detention Standards, NDS 2000, Performance-Based National Detention Standards, PBNDS 2008, as well as the PBNDS 2011. All ICE detention standards specify the living conditions appropriate for detainees and help to ensure a safe and secure environment and cover such areas such as medical care, food service, environmental health and safety, segregation, access to legal and religious services, as well as visitation. ICE's requirements exceed industry standards, which is evident from the large number of local jails who are unwilling to meet ICE's more rigorous requirements and have instead elected to detain other populations. PBNDS 2011 was recently revised in 2016 to include important updated standards on disability identification, assessment, and accommodation, as well as medical care for women. To ensure ICE's detention facilities meet the requisite standards, ICE provides oversight through a multi-layered inspections and monitoring program. ICE conducts annual and biannual inspections of all facilities over a certain population and utilizes a self-inspection process for facilities with small populations or those that house detainees for under 72 hours. Additionally, the ICE Office of Detention Oversight, the DHS CRCL, and the DHS OIG all conduct reviews and inspections and have open access to ICE detention facilities. ICE has also enlisted the services of the Nakamoto Group to inspect facilities around the country. This includes annual inspections, pre-occupancy inspections, special reviews as ordered by ICE using the applicable detention standards. Contract inspectors typically spend 3 days auditing each facility, and in addition to an environmental health and safety subject matter expert, they also employ the services of a health professional and a detainee rights subject matter expert. When deficiencies are found during any type of inspection, ERO works with field offices and facilities to ensure timely and corrective actions are implemented. ICE greatly appreciates the work conducted by the OIG regarding the inspection process and carefully evaluates its recommendations. In a June 26, 2018 report entitled ICE's Inspections and Monitoring of Detention Facilities Do Not Lead to Sustained Compliance or Systemic Improvements, the IG made 5 recommendations with which ICE concurred and which have been used to implement improvements to our inspections process. In response to OIG's finding, ICE is reevaluating the existing inspection scope and methodology in the statement of work for its inspections contract to ensure inspection procedures are adequately and appropriately resourced to fully evaluate detention conditions. ICE has also created a quality assurance team consisting of seasoned federal employees to perform quality assurance reviews of ICE's contract inspections during each annual inspection. ICE is also developing follow-up inspections processes for select facilities where egregious or numerous deficiencies are identified, updating and enhancing current procedures to ensure verification of all corrective actions, including better tracking of all corrective actions by facility and responsible field office, as well as developing protocols for ERO offices to require facilities to implement formal corrective action plans resulting from deficiencies identified from its on-site monitors. ICE understands
Mr.
that
Johnson,
immigration...
Your time has expired. If you want to conclude with a sentence.
Sure. Thank you for the opportunity to testify today regarding this important matter, and I look forward to answering any questions you guys may have. Thanks.
I thank all of the witnesses for their testimony, and I'll remind each member that he or she will have 5 minutes to question the panel. I'll now recognize myself for questions. We've been talking a lot about these 600 elements and the scope of work. And this process for Nakamoto differs from the Office of Detention Oversight, or ODO, which has a much narrower scope of inspection and allows them to more deeply assess the health and safety of detainees. OIG's recommendations for ICE is to revise the inspection scope and methodology for contracted inspectors within ICE's statement of work. Ms. Shaw, do you believe that ICE's current statement of work keeps its contractors from fully complying with its oversight responsibilities?
So based on our observations related to that report, we found that it was an incredibly challenging goal that had been set for the inspectors to try to review the full scope of the 39 to 42 applicable standards in a 3-day period with a 4 to 5 person team is a tall order. Based on our experienced and highly trained staff, I think they felt that they too would have struggled to try to meet those goals. So the statement of work, the breadth of the statement of work makes it very difficult to get any sort of a deep dive into some of these issues.
Should ICE revise its statement of work to ensure quality inspections to assess compliance with detention standards? You don't have to you can just say yes if that's...
Yes, that's our recommendation.
Great. Have you seen any plans to amend the new statement of work that satisfies your recommendations?
That recommendation continues to be open and treated resolved, meaning that we are continuing to work with ICE on their corrective action. We've seen iterations, possible ways that they might revise the scope, but nothing definitive has been decided at this point. And based on our most recent update, because they are putting out requests for proposals on that contract, I think that will potentially slow down the process slightly, but we would continue to suggest that regardless of who their contractor is, they need to revise that statement of work to ensure that they're getting detailed findings.
Now, when you say it would slow down the process, you mean an RFP would go out without changing the scope of work, and there might be a new contract without changing the scope of work?
So I'm speaking based on our understanding from what we've been hearing from ICE, but the latest update that we received was that they were putting out a request for proposal, and so they had not provided a new update on the status of their revisions to the statement of work.
Does that concern you?
I think just based on the little bit that I know about how contracts are done, I think it is important to have a clearly defined statement of work, at least in mind, when you're going through that process. But
Thank
I
you.
defer to ICE.
Thank you. Mr. Johnson, what is the status of the plans identified by Ms. Shaw?
As Ms. Shaw stated, we're in the middle of a recompete, and the plan to increase or make the needed improvements in our statement of work have been sort of drafted in the current competition, or in the new competition that's coming, and we expect to do an award within the next 3 months.
So will you commit to revising the scope of work before finishing the RFP process?
Yes, the new requirements will be included in the new contract going forward, correct.
Ms. Shaw, are you planning any follow-up work to evaluate whether Nakamoto's inspections have been improved?
We currently don't have planned work in that area, but it is the case that as part of our recommendation follow-up process, we are consistently obtaining updates from ICE based on how well they're implementing their corrective action plans. So we would expect to get some updates through that process. We will continue our unannounced inspections program next year and visit facilities, many of which will have been reviewed by Nakamoto, and that will give us another opportunity. And as part of our pre-inspection scoping work, we do look at what Nakamoto has found to evaluate whether we're seeing corrections when we're on site or not.
Thank you. And in the short time I have left, I just want to bring up the issue of penalties versus waivers. So in 2.5 years, ICE has issued only 2 financial penalties, but offered 65 waivers, including allowing the use of spray that is 10 times more toxic than pepper spray, strip searches in 9 different facilities that don't comport to ICE standards, and in my own district, permitting the commingling of detainees with varying criminal histories, including, which is, you mentioned, threat levels. Mr. Johnson, what's the point of standards if ICE simply uses waivers to sanction noncompliance?
So I think first it's important to note that the only provisions that ICE has ever issued waivers on are things that are certainly not a health
Mixed
safety
threat
standard.
levels doesn't affect health and safety?
So classification is really important for housing and for recreation.
I apologize, I'm out of time. Thank you. I now recognize the ranking member of the subcommittee, the gentleman from Texas, Mr. Crenshaw, for 5 minutes of questions.
Thank you, Madam Chairwoman. Want to just continue your answer, Mr. Johnson?
Sure, thank you, sir. So historically, classification is generally sort of held for housing as well as recreation. Those are the areas where detainees or inmates generally are most vulnerable. In your specific instance, the only waiver of a sort of a classification requirement had to do with whether an individual who was going from their housing unit or to the medical area needed to be escorted by an officer during as the standards require. So that's an area that we've sort of waived in the past because, you know, it sort of cuts against the whole idea of civil detention to escort level 3s, and it should be really based on the threat that the particular detainee sort of poses as opposed to just the fact that he may have had a marital dispute with his wife, and that's why the individual is classified as a level 3. So I really think you have to just look at the specific circumstances of the waiver before you can just sort of conclude that ICE's waiver has somehow made an individual unsafe or vulnerable, because we would never grant a
Okay,
waiver.
so in that example, it's not necessarily the case that a violent criminal was put in a cell with a nonviolent.
That is correct.
Grant.
Classification, housing is what would always be.
Is there additional explanation, circumstances to the other waivers that the chairwoman?
Sure, there's a
talked
number
about?
of waivers. I mean, a lot of the waivers that we've granted are for things that, were sort of written in our standards 20 years ago that are no longer sound detention practices. The most popular waiver that we grant has to do with the barbershop provision, which requires that the barbershop be in a dedicated area of the facility, that the barbershop have a.
Well, I know about those.
trained-
I meant specifically what the chairwoman had alluded to. Was there additional explanation that would explain those particular waivers? I think she mentioned pepper spray and.
Yeah, I'm not familiar with the pepper spray waiver. I'm happy to take a close look into that.
Let's move on to the discussion of scope. So the IG report talks about there's too much scope for the contractors. There's very narrow scope for the ODO. Is the recommendation particularly to do everything like the ODO to narrow the scope, or is it there's some middle ground that was recommended by the IG?
So our recommendation specific to ODO was a higher frequency of inspections.
Higher frequency, but maintain the scope that they use?
Correct.
And do you recommend that same scope be used for Nakamoto as well?
We did not. We left it to ICE to revise the statement of work according to what they
Okay.
felt would allow them to achieve compliance in their standards.
And Mr. Johnson, so what is ICE's position on that?
Yeah, I mean, I think our position is that we have 39 or 42 standards, depending on which version of the standards are applicable. We have
What differentiates between those standards?
so the more robust standards, the PBNDS 2011, which are generally applicable at our dedicated facilities or facilities that house only, or for the most part, or close to nearly all ICE detainees. Our more robust standards are sort of tailored to those facilities. We have our lower version of the standards, which are the national detention standards, which are generally for our local jails, where we have shared populations and in many instances a relatively small ICE population compared to the overall large inmate population.
Is there any benefit to sort of commingling the contractors with ODO to ensure, I guess, more consistency in inspections?
From my perspective, no. I mean, I think from ICE's, we're getting exactly what we expect out of our inspections. We have to inspect against all of the requirements. We have sort of developed that checklist to sort of to identify what we believe are the
You
most
like keeping
critical
those
elements
separate?
of each. Correct.
And just getting to the root causes of this, given the vast amount of detainees in custody that peaked this summer to 54,000, to what extent does that put increased pressure on your operations in these facilities?
So, I mean, we had to activate a lot of new facilities. Many facilities had never held ICE detainees previously, so for those, it was a huge learning curve for them to sort of figure out and learn what the inspections required. So, I mean, I'm sure for some of those folks, it was a little challenging at times. So it did impact the operations.
Thank you. Madam Chair.
Thank you. Thank you, Mr. Johnson and Ms. Shaw, for your testimony. Mr. Johnson, how many employees do you have that oversee or work with these facilities that have detainees?
I have about 200 or so direct reports, and the folks that actually focus on detention, I'd say about half of those, about 100, 120.
100 do what? I'm sorry.
I said 100 to 120.
And they do what? You were distinguishing them as?
Detention operations. So
Okay. How many facilities are you responsible for ensuring that the standards of care are appropriate?
So today we use about 250 facilities.
So your 120 inspectors, so to inspection people, how do they determine which facilities? They do the smaller facilities, and Nakamoto does the larger facilities?
So Nakamoto inspects all the facilities that we use that house people for over 72 hours. I have on-site detention service managers at our largest facilities, and they cover about 50 facilities and reach about 70% of our population.
And I'm sorry, did you tell me there are 250 facilities altogether?
That is correct.
And of those, have you had occasion to close any for deficiency in service, unsafe conditions?
We have closed several facilities.
How many, several?
Over the last 10 years, I'd say.
Tell me about the last 3 years.
3 years, I don't recall offhand how many we've shut down.
So Nakamoto's group provides a report of their findings, right?
Right.
Those are recommendations to your department?
That is correct.
Okay. Do you, under any circumstances, ignore their findings and recommendations?
Generally, no.
Generally no, or
Generally,
never no?
no. I mean,
You have then?
I mean, I recall one instance where we disagreed with a particular recommendation, and we went back to them and had a discussion and explained our position. And
So there is a mention in my briefing here that there was an instance where ICE let recommendations that came from Nakamoto to you all penned for an extended period of time, over 100 days. Does that come to your recollection?
so vaguely, I do remember a statement that seemed to suggest that there was a inspection that was sort of sitting in a draft status for an extended period of time.
What is the amount of time that those recommendations stand waiting for a response from you all? Do you have a requirement in terms of response time?
There is no requirement. I mean, I think folks generally try to get those reports finalized sooner rather than later, but there could have been a technical issue with that, with the.
So what is the follow-up on telling a facility that it has X number of violations and that they have to clean them up? What is the process for follow-up?
So once the report is finalized, a uniform corrective action plan is generated that is sent to the field office and the facility for any serious life safety issue. They're required to come up with a corrective action plan in short order. I think it's a week, maybe 2 weeks, for any sort of regular sort of.
No, my question is, when you have these deficiencies brought to your attention, and you tell the facility you have X number of days or whatever to correct it, what is your follow-up?
So
To ensure that what you tell them to do, they do.
So at our DSM staff facilities, where we actually have on-site staff, we have a presence there, and we can ensure that the things they said they were going to do were in fact done.
How many facilities have on-site staff?
About 50.
And are they
work-
like full-time in that one
These are
facility?
full-time folks that spend the overwhelming majority of the time. Now, they could have another facility close by that they have to provide roving coverage of, but generally, they're
In the last couple of years, have you all used your financial penalties to get a facility to do what you needed them to do to meet the standards?
we have,
And so how many?
more than two. I heard earlier that had only occurred twice. It's at least been 10, 15 that I'm aware of, but we could get you an exact number.
I've asked Mr. Crenshaw if he wanted a second round, and he said that it wasn't necessary, so I'm going to indulge myself a minute. I'm not quite sure why we're having all this consternation about inspections of facilities, meeting standards, and whether or not the standards are relevant, whether or not the scope of the standards are doable and make sense, and why we don't have the kind of follow-up that we're supposed to have. So my question to you, Ms. Shaw, Do we need extra people, or do we need streamlining of operation, or do we need better commitment?
I think based on our recommendations, the primary issue that we have is really a process one, ensuring that there is adequate follow-up, that there's documentation to support claims by the facilities that they've implemented corrective action. So they need a more robust process for ensuring follow-up.
Does that mean that you need more staff, sir?
I mean, I'd like to have more staff at our larger facilities to make sure we have that on-site presence to monitor conditions each day. So certainly the staff would be welcome.
Okay, my last question. How do you do quality control checking of your contract E, Nakamoto?
So what I would say is 10 years ago, the government used to inspect its own facilities, but after a lot of criticism about...
No, my question is, what do you do to ensure that Nakamoto is doing the job you contracted them to do?
So today, we have seasoned federal employees that accompany Nakamoto on every inspection. They have a role in the inspections process, but they will, from this point forward, be monitoring the inspector to make sure that they're providing the services that we're paying for.
Thank you, Mr. Johnson. Thank you, Ms. Shaw and Mr. Johnson, and to the witnesses in our first panel, thank you for being here and taking our questions and giving us your testimony. Before adjourning, I'd ask for unanimous consent to submit statements to the record from the American Civil Liberties Union, the Detention Watch Network, the American Immigration Council, the National Immigration Justice Center, the Government Accountability Project, the Southern Poverty Law Center, the Transgender Law Center, and the Asian American Advancing Justice. Without objection, so admitted. The members of a subcommittee may have additional questions for the witnesses, and we may ask that you respond expeditiously in writing to those questions. Without objection, the committee record shall be kept open for 10 days. Hearing no further business, the subcommittee stands adjourned.